From today, I'll give you the important update regarding leave to remain. Those who are on 10 years route, especially the Home Office a concession regarding some young people which is 18 to 24. They can apply early for ILR or settlement rather than wait for complete 10 years. So after 5 years, they can apply. What is the requirement? I'll discuss and try to give you some important information. Other important update about regarding extended family member. That is the EU family member, which, as you know, the extended family member are not eligible to apply under EU settlement scheme. However, those extended family member who was qualified and applied before the deadline, they can now, they will be allowed to come to the UK, those whose application was successful. Secondly, also those who successfully appeal or appeal is pending, they have also an update. I'll give you a brief background as well. And another one, deprivation of British citizenship. So these are the main three important update, and there's also some issues which I'll discuss if time allow me, and if anyone asks me a related question, I'll try to give a brief answer today. So let me start with update. If you have any question, please leave a comment and I'll give you your answer after these three updates. So let me start with early settlement concession for those individual, which is basically some young people who are aged 18 to 24, either born in the UK or came from outside the UK, but they spend more than half of their life. This is basically, as you know, the human rights based application. There are four circumstances where someone can claim leave to remain on the basis of human rights. However, once they granted visa, they need to wait for 10 years and they need to extend 2.5 years like this. They need to complete 4 applications, and once they complete the 10 years, then they can apply indefinitely to remain. However, Home Office gave a special concession for those young people who is aged between 18 to 24, born or brought up in the UK without immigration status, can now apply for settlement after 5 years rather than 10. What you need to satisfy that be aged 18 years or above and under 25 years of age and has spent at least half of their life or his or her life continuously in the UK, and or either born or enter UK as a child under 18 years, have held 5 years limited leave to remain, and be eligible further leave to remain. So if you can satisfy these 4 requirements, then after 5 years you can apply to the Home Office. You can request to the Home Office to give you ILR on the basis of the recent concession which is introduced by the Home Office. And I think this is very important for many people, because many people came in the UK. However, they cannot apply for ILR until they complete 10 years limited leave to remain. However, under the current concession, so they can apply after 5 years rather than wait for 10 years. The next one is extended family member. As you know, many European citizens, the European nationals who are living in the UK as a qualified person, they could bring their family member, an extended family member. Family member is defined by Regulation 7. I'm giving the reference from the EU regulation because this the right was based on EU regulation, not EU settlement scheme. Although the current Home Office position is they will granted a family permit for the extended family member. So under Regulation 7, define EU family member means spouse, and then their children under 18, under 21, their dependent parents. An extended family member defined in Regulation 8, those dependent relative, they are for because of their financial circumstance, they are dependent on EU nationals, or because of their health needs, they need care from the EU nationals, or if they used to live same household. But most of the EU extended family member, like brother, sisters, uncle, auntie, further really extended family members, extended relatives, they are dependent financially on EU nationals. They had a right under regulation, means under EU law. So 31st December 2020, there was a deadline. So many people applied to bring their extended family member in the UK. However, once UK left European Union, and under the EU settlement scheme, there is no provision to apply for EU extended family member. So many people the granted EU family permit. Some people refused, but later the appeal win. However, after the appeal, or after granted the family permit, Home Office refused them to come to the UK, or refused to issue family permit on the ground that under the EU settlement scheme there is no provision, they cannot issue family permit, they cannot travel. That was unreasonable and unlawful. Many practitioners like me, I lots of client whose family permit was refused despite the appeal, and we applied for a judicial review, and many practitioners, many clients challenged by UF judicial review. However, before it go to the court, what happened? The Home Office now agreed on the basis of the last meeting with the European Union that under the withdrawal agreement, the UK agreed to protect citizen rights and their family member. However, as they're not complying with this, which is breach of withdrawal agreement, and on top of this, the threat of judicial review. So now Home Office agreed that they will give a concession for the extended family member, means those EU citizen who applied before 31st December 2020 to invite their extended family member to come to the UK, or those whose appeal was successful, and those whose appeal is still pending to the court. If they would qualified as extended family member, the Home Office said they will issue a special concession, and they will issue a EU family permit as an extended family member, although there is no provision in the EU settlement scheme. That means those EU extended family member who applied for a family permit prior to 31st December 2020, now they will able to come to the UK if they would qualified for the family permit requirement. Now there is a couple of scenarios. So some people applied, but their application refused, the appeal is pending. Some people applied, the application refused, the appeal was successful. Some people got family permit, however they unable to travel in the UK due to COVID, due to travel restriction, due to Home Office say you cannot travel, so many reasons. But whatever it is, if they would qualify and satisfy the eligibility requirement before 31st December 2020, then now they can come to the UK under the concession which is going to be placed in the EU settlement scheme. So the Home Office amend and update the EU settlement scheme policy guidelines. If you look into the page 11 of the current EU settlement scheme, you'll see there is a guidelines regarding how they will deal with extended family member application for for family permit under EU settlement scheme. Moving to the next, so those EU extended family member, if you need any help, please contact with the relevant the department, or you can contact to the EU settlement scheme, or in Liverpool contact with the Home Office, or if you have a solicitor, ask them to contact and made an arrangement for EU family permit. Let's move to British deprivation of British citizenship. This is also very important for those. It is relevant for the British citizen, especially those who who basically naturalized British citizen. Under Section 40 of the Nationality Act 1981, Home Office can Home Office can deprive your your citizenship. They can withdraw your citizenship once they issued by you of naturalization or by any registration. Home Office has, the Home Secretary has authority to terminate your citizenship, to curtail your citizenship, or revoke your citizenship under Section 40 on the public interest ground. However, under Section 40, subsection 5, the Home Secretary, under obligation to issue a written notice to the British citizen that they're going to take you your citizenship because of this reason, because of public interest. That was the formality. However, the introduction of the Immigration Act 2021, now the Home Office, Home Secretary doesn't need to notify to the relevant British citizen that I'm going to take you your your citizenship. That is very unfair for me. For example, the person whose British citizenship was withdrawn, even he will not know about it, that his citizenship go away. So this is the situation. So we don't know yet what is the future of this amendment. However, what the Home Secretary has this authority is basically for the protection of public. But I'm not sure whether it will be misused in future. But looks like it will be mainly applied for the terrorism, those who involved in ISI, involved in international terrorism, their citizen will be taken away, and the Home Secretary with that amendment to deprive the nationality. So it is very careful for British citizen who, especially for who naturalized in the UK, if you have to be very careful about your your involvement with any other groups, foreign political group or terrorist group. So there is a threat. Even you will not have an opportunity to challenge the Home Secretary, because maybe you don't know, you will travel to outside the UK. When you will come to the foreign airport to come to the UK, they will stop you, say your passport is no more valid because the UK authority has taken away your citizenship. So these are the three important update. I'll give you some more update regarding European law. Let me go to, okay, then I will move to a new case which came from asylum related again, which is claiming humanitarian protection in the medical treatment case. So as we know, under Article 3, someone, if someone become a severe sick, where the circumstance is the treatment what he is receiving in the UK, he will not get it in his home country. These types of situation, someone can claim asylum in the UK on the medical ground, what is known to be popular for many people. However, if you want, you can also claim humanitarian protection on medical treatment cases. Humanitarian protection can be granted if someone would face a serious risk of serious harm, including torture or inhuman or degrading treatment or punishment. Seriously ill migrant claiming humanitarian protection status must show that the prosecutor, some country, some authority or some political group will deprive him or them from taking medical treatment on his home country. If someone can satisfy this requirement, then what are the upper tribunal confirm in the case NM Article 15B intentional requirement, Iraq 2021, which is the most recent case. Someone claim humanitarian protection, but what he needs to satisfy the Home Office that he will be deprived from medical treatment if he required to return to his home country. There are also lots of case law and observation in medical grounds asylum cases that is not only because the Home Office position is they refuse the application on under Article 8 on the ground that the treatment is available on the home country. For example, if someone from India or from Ghana claim asylum in the UK that I have a cancer, I will not get the treatment on return to home because of blah blah this reason. Home Office position is the medical facility in India or Nigeria is very well and they can get this treatment. And normally what the Home Office do, they give a list of hospitals names and their website, and they see the treatment, what treatment available, and providing evidence, and they refuse your application that this treatment available in your home country. However, in many cases, in the Supreme Court, Court of Appeal, what the judges said in the judgment, that it's not only a viability, this should be considered whether it is affordable for someone or not. So that means if someone live in the UK for 10 years, and if he doesn't any income, doesn't have enough money to get treatment in an expensive hospital, then that means he will not get this treatment, he will not afford this treatment, and on that ground he can claim a humanitarian protection, that I will not be able to get this treatment. That means if I require to leave UK, I have to die. And then he can involve the Article 8 as well, and with the Article 3, because remember, Article 8 also sorry, excuse me. So Article 2, Article 3, and when you both put together, then the weight of your claim, weight of your application will be very high, because right to life is a unconditional absolute human rights that can't be breached under any circumstance. Article 8 is conditional rights. So if the Home Office required for public interest, they can breach it. However, if Article 8, that is breach of family life or private life, that can't be breached for public interest. So that's what is also important for many people. Secondly, I would like to also give you some update regarding the new policy guidelines for asylum support. Many people in the UK who seek asylum, however, in some circumstances, they cannot get any additional support from the Home Office. So the new guidelines define that additional support means, or any support means, financial support or accommodation support or housing support. These are the support. So in asylum cases, when someone seek asylum, they can immediately apply to the Home Office for housing support, for the financial support from the Home Office. And it doesn't matter whether your application is successful or not. Once you applied, once you seek asylum, you can straight away make this application. Even though once that they decide your claim, if the Home Office refused your application, they refused your asylum claim, still that time you can continue to claim this support from the Home Office. But what you need to do, you need to make the correct application to get this support. Generally, in one stage, once the Home Office refused the claim, what the Home Office do, Home Office also stop the paying your credit, what the credit £39 they pay, they stop it. But you can appeal it, you can challenge it, or you can make another application by using the form to ASF1 and ASF2 if you need additional support. Now the other thing also you need to remember, that if you just make an application, you will not get the money. What you need to satisfy that you are a destitute. There is a couple of provision to make this application. So mainly Section 95 under the Immigration and Asylum Act 1999, Section 98, and Section 4 also claim. So it is also known to be NAS support. So if you want to make any of this application, what you need to satisfy to the Home Office or the caseworker that you are a destitute. Who are the destitute? The destitute are those people who basically they don't have adequate accommodation or any means of obtaining it. So they don't have adequate accommodation or any means of obtaining it, whether or not the other essential living needs are met, or have adequate accommodation or the means of obtaining it but cannot meet their essential living needs. So if you can satisfy these then you are a destitute. In my observation, my opinion, 100% asylum seeker, they are destitute. They don't have housing, they don't have finance, and they don't have a place to live, they don't have food to eat. So they are the destitute people. So that's what the update, the destitution definition, the policy guideline which is published recently. So if you are a destitute, if you seek asylum, or if your asylum is pending, or if your asylum claim is refused, you can make an application to the Home Office for accommodation, housing support, or financial needs, and hopefully you will get additional support if you need from the Home Office. And today update is basically for the whole month, because I'm a bit busy now currently, so I cannot manage to come on live Facebook. I was in holiday, so I came after a long time. So I'll give you another update about seasonal worker visa, new introduction of 3 category of visa, which is temporary seasonal worker visa introduced by the Home Office, which is I already gave some update, and many of you know about it. So new immigration concession for this is mainly HGB driver and poultry worker visa. So poultry worker visa is around 5,500 poultry worker visa introduced by the Home Office, and 800 pork butcher, which is temporary worker visa, introduced by the Home Office, and 4,700 lorry driver, food driver visa introduced by the Home Office. So the new introduction of 3 types of visa available, but of course this is basically if any firm in the UK, if any poultry farm or any butcher shops or any HDB lorry company need the people, then the Home Office give food company license. So they are the recruitment agency. The employer need to contact with them, and they will arrange these people to come to the UK. So the applicant, how you can come, if applicant want to come to the UK, what you need to do, you need to give your CV and register with this 4 recruitment agency, and when any UK employer need any people, they will contact with them, and the recruitment agency will arrange your visa to come to the UK. So this is about the temporary worker visa, and the many student is coming. This is my last important piece of information for you. Many students are coming into the UK from Bangladesh, Pakistan, India, and many of you have a good future. You will study in the UK, you will have a good job, you will get a 2 years post-study work permit. But remember one thing, it is very important for you is once you come to the UK, you must carry on your study, because many students already has made a plan that they will seek asylum in the UK. It's not very easy to success your asylum. It's not something what you play a game and abuse the asylum system to get a visa for 5 years in the UK. Asylum is those people who basically need support, need protection. This is an international law. So of course, if you are in a situation, then you can claim it. However, if you want to take an advantage, then you will have a not good future. We know many people in the UK living long time, their asylum refused. So my advice would be, if you come to the UK on a student visa, carry on your study, do some sacrifice, do hard work for 1 year, complete your education, and then you'll get 2 years work permit to make money. Don't be greedy on your first year or during your study, because if you become greedy for money on your first year during your education, you will destroy your career, your future. Especially from Bangladeshi student, they come here and they're looking for alternative, some route, something to do, something, either marriage or either a work permit or either asylum or human rights claim. We are practical, we are professional, we deal with many people's application in the UK. It's not a good option to exercise these 3. Try to study. You come to the UK, pay a lot of money, some fees are due. Please study, carry on study. If you study in the UK, you will have a good future. 1 year complete the master, complete the graduation, and then switch to a post-study work permit visa for 2 years. And then if you work in the 2 years, you will get a good opportunity to switch any work permit visa. I hope and I wish all of you good luck and good future in the UK. But once you come here, then don't talk with the people who give you a way to do fraud, because now if you do fraud and you obtain something alternative visa, remember, even though you will become a British citizen, anytime you will caught, your British citizen will take any without any notice. So it is important to carry on study in the UK. Everyone, take care. Have a nice weekend. After evening, enjoy rest of the evening, and I hope you will be benefited from this information what I'm sharing with you. Thank you very much.